I am Dr. R.K.RISHNAVENI, Associate Professor in PG and Research Department of Commerce, A.D.M. College for Women, Autonomous, Nagapattinam. I am going to present a paper on corporate law. Next, I am going to say about the introduction for corporate law, the content, definition of companies, the features of companies, company versus body corporate, corporate personality, lifting the corporate weight, and the difference between the Companies Act 2013 and Companies Act 1956. Meaning and definition of companies. Meaning of a company. A company is a voluntary association of persons who have come together for carrying on some business and sharing profit therefrom. Definition of joint stock company. Joint stock company may be defined as a voluntary association of persons formed for some common purpose with a capital divisible into transferable shares, limited liability with a distinctive name, having a corporate body and legal personality of its own. Next, we will see about the salient features. The first one, the class action suit for shareholders. The Companies Act 2013 has introduced a new concept of class action suits with a view of making shareholders and other stakeholders more informed and knowledgeable about their rights. The second feature, more power for shareholders. The Companies Act 2013 provides for approvals from the shareholders on various significant transactions. Next one, the women empowerment in the corporate sector. Companies Act 2013 stipulates the appointment of at least one women director on the board for certain class of companies. Corporate social responsibility. The Companies Act 2013 stipulates certain class of companies to spend a certain amount of money every year on their activities, initiatives reflecting the corporate social responsibility. National Company Law Tribunal. This is another feature. The Companies Act 2013 introduced the National Company Law Tribunal and the National Company Law Appellate Tribunal to replace the Company Law Board and Board for Industrial and Financial Reconstruction. They would reveal the court of their burden while simultaneously providing the specialized justice. Another feature, fast track mergers. The Companies Act 2013 proposes a fast track and simplified procedure for merger and amalgamation of certain classes of companies such as holding and subsidiary companies and small companies after obtaining an approval with the Indian government. The cross-border merger is another feature. The Companies Act 2013 permits the cross-border mergers, both ways, a foreign company merging with an Indian company and vice versa, but with the prior permission of RBI, prohibition on forward dealings and insider trading. The Companies Act 2013 prohibits directors and the key managerial personnel from purchasing the calls and put option of shares of the company. If such a person is reasonable expected to have access to the price sensitive information. Another feature, increase in number of shareholders. In Companies Act 2013 increased the number of maximum shareholders in private company 50 to 200. Limit on maximum partners. The maximum number of person or partners in any association or partnership may be up to such a number as may be prescribed, but not exceeding 100. This restriction will not apply to an association or partnership constituted by the professionals like lawyer, chartered accountant, company secretaries, etc., who are governed by their special law. And one-person company is another feature. The Companies Act 2013 provides a new form of private company, that is one-person company. It may have only one director and one shareholder. The Companies Act 1956 requires a minimum 2 shareholders and 2 directors in the case of private company. Enrichment in the Article of Association. The Companies Act 2013 provides for an enrichment applying the extra legal safeguard of Articles of Association have been introduced. Electronic mode is another feature. Companies Act 2013 proposed the e-governance or various companies processes like maintenance and inspection of documents in electronic form, option of keeping of books of accounts in electronic form, financial statements to be placed on the company's websites, etc. Indian resident as director is another feature. Every company shall have at least one director who have stayed in India for a total period of not less than 182 days in the previous calendar year. Then they have to be a resident as director. Independent director, another feature, independent director. Companies Act 2013 provides that all listed companies should have at least 1/3 of the board as an independent director. Such other classes or any classes of public companies may be prescribed by the central government shall be required to appoint an independent director. No independent director shall hold office for more than 2 consecutive terms of 5 years. Servicing notice of board meeting. This is another feature. The Companies Act 2013 requires at least 7-day notice to call a board meeting. The notice may be sent by electronic mode to every director at his address registered with the company. Duties of directors is also defined. Under Companies Act 1956, a director had a legal or ethical relationship of trust duties towards the company. However, the Companies Act in 2013 has defined as that only the duties of directors, liability on directors and officers. The Companies Act 2013 does not restrict the Indian company from indemnifying compensate for a harm or loss its directors and officers like the Companies Act 1956. Then rotation of auditor. The Companies Act 2013 provides for rotation of auditors and audit firm in the case of public traded companies. Prohibits the auditors from performing a non-audit services. The Companies Act 2013 prohibits the auditors from performing a non-audit service to the company, where they are an auditor to ensure the independence and accountability of one auditor. Rehabilitation and liquidation processes. The entire rehabilitation and liquidation processes of the company in a financial crisis has been made time-bound under Companies Act 2013. And another one, the company versus body corporate. The term body corporate is defined in Section 2, subsection 7 of the Companies Act as body corporate includes a company incorporated outside India but does not include a corporate soul or a cooperative society. Any other body corporate which the central government may specify by notification. Corporation soul refers to a single individual constitute a corporation in respect of some office or functions. For an example, a president, a governor, minister. A corporation soul is not a body corporate under the Companies Act, though it is very much a legal person capable of holding a property and becoming a member of a company. Thus, broadly speaking, a body corporate may include any aggregate of person which is incorporated under some statute of country or any foreign country and which exists having a perpetual succession and a common seal. On the contrary, a company means a company formed and registered under the Companies Act. A corporate personality. A company is a legal representation of itself and is separated from its promoters of the firm, who may be the partner, shareholders or managers of the company. Hence, it is called a corporate personality. A company is born by its registration at the Registrar of Companies and is legal and independent property of itself. A company's personality is a corporate personality as it represents the transactions of commercial and non-commercial, but it is not entitled to fundamental rights. Corporate personality, a company is said to be a corporate personality because a company has a legal entity, a company can hold property, a company can sue, a company has a nationality, a company is registered and has a place of existence, and company is being taxed for its operation and so on. And another one, we will see about the lifting corporate veil, meaning of a corporate veil. When a company is formed and registered under the Companies Act, the company acquires an independent legal entity, quite distinct from the members. This clearly indicates when the company is incorporated, all transactions should be with the company only and not with individuals of the company. However, the important they are who may be behind its operation. It means that there is a veil drawn between the company and its members. Normally, the principles of the corporate personality of a company is respected, and in many cases, the court have refused to go behind the curtain to find out the real person composing the company. But when the people start misusing the veil of corporate personnel, then it becomes necessary for the court to pierce the corporate veil and look the person who are in fact the real beneficiaries. This is known as lifting of piercing the corporate veil. It refers to the identification of company with its members, and the veil is lifted. The individual members may be held liable for its act. The corporate may be lifted under the following circumstances. Lifting of corporate veil. For determining the character or the status of a company, when it is suspected that the company is owned or controlled by the enemies of the country, the court may lift the corporate veil and examine the character of a person in control of a company. Second one, for the protection of revenue. If the company used as a means to evade tax, the court may disregard the corporate veil. Then for preventing the fraud or improper contact, the court may also lift the corporate veil of a company where it appears the company was formed only for some fraudulent purposes to defraud the creditors or to avoid the legal obligation. The company acting as an agent of the shareholders. As a general rule, the company is not an agent of its shareholders, but under certain circumstances, the company may be regarded as an agent or trustees of its member, where the doctrine of conflict with the public policy, where the corporate veil conflict the public policy, the court lifts the veil for protecting the public policy. Where the doctrine conflicts with the public policy, where the corporate veil conflict with the public policy, the court lifts the veil for protecting the public policy. And another one, in case of a commitment of economic offences, in case of an commitment of economic offences in the court, is entitled to lift the corporate veil and pay regard the economic realities behind the legal facade. to punish those who indulge the contempt of court. And another one for determining the technical competence of a company. The Supreme Court in this case held that experience of the promoters would well be considered as an experience of the company in determining its technical competence, where the company is a mere cloak or sham. The corporate veil may be lifted to identify the company and its members when it is found that the corporate bodies were mere the cloaks and that the devices of the incorporation was really a policy adopting for committing the illegalities and to fraud the people. The last one, the ultra vires the act. Directors of the company shall be personally liable for acts committed by them, and if such act committed or ultra vires, a company should not rectify their act. Thus, in all the above cases, the corporate veil shall be lifted, and the members cannot hide behind the corporate veil. The company, though the justice person, does not possess the body of a human being. It exists only in the contemplation of law. Being an artificial person, it has to depend upon the natural persons for getting its various work done. Although the company is a legal person, it is not regarded as a citizen of India, either under the Constitution of Indian or under Citizenship Act 1955. The corporation may have the nationality in accordance with the country incorporation, but the government does not necessarily confer any citizenship on them. This is because the Constitution of India clearly distinguishes the citizens from persons. When the lifting corporate veil exists, the law of land court may lift the corporate veil during two instances: common law exceptions and statutory exception. The common law exception includes the judicial interpretations, while the statutory exemption includes the statutory norms of the company law. Common law exception includes determinations of the characters of the company, where the company is a sham, prevention of fraud or improper contact, where the company is acting as an agent of the shareholders, protection of revenue, avoidance of welfare legislation, punishment of contempt of court, ascertaining the true nature of transaction if alleged as sham, determination of technical competence of the company, formation of subsidiary company to act as an agent. In this case, the common law is included. In the case of statutory exemption, these includes the statutory exemptions, number of members below the statutory limit minimum, or when the company not mentioned in the bill of exchange, or whether the group accounts or investigation into related companies, failure to refund the application money, fraudulent trading, investigations on the ownership of company, liability for ultra vires, etc. In that case, the statutory exemption is followed. With this, in the very beginning, we have seen the features. With that features, we can able to differentiate what is the difference between the Companies Act 1956 and Companies Act 2013. It is a one-person company, corporate social responsibility and national company law tribunal, reconstruction of company, class action suit, cross-border merger, prohibitions on forward dealings and insider trading, and the strict rules for auditors, increase in number of shareholders, enrichment in articles of association, electronic mode, and the Indian resident as a director, independent directors, servicing a notice of board meeting, duties of directors are also defined, the liability on directors and officers we have seen in the features. With this, we can able to explain the difference between the Companies Act 1956 and 2013. The one-person company means a new form of a private company, that is one-person company. It may have only one director and one shareholders. The Companies Act 1956 requires minimum two shareholders and two directors in the case of private company. And another one, the corporate social responsibility in 2013, it stipulates certain class of companies to spend a certain amount of money every year on activities, initiatives reflecting their corporate social responsibility, but not in 1956. And National Company Law Tribunal in 2013, we are introducing the National Law Tribunal and National Company Law Appellate Tribunal to replace the Company Law Board and the Board for Industrial and Financial, but it is not in 1956. Reconstruction, they would relieve the court of their burden whilst simultaneously providing the specialized justice in 2013. And when you say about the class action suit, the Companies Act 2013 has introduced a new concept, the class action suit, with a view of making the shareholders and other stakeholders more informed about the knowledgeable about their rights, but it is not in 1956. The cross-border merger is also another, it permits the cross-border merger both away in foreign company merging with an Indian company and vice versa. But with the prior permission, they have to get the RBI permission, then only they can have the cross-border merger, but it is not in 1956. The prohibition on forward dealing and insider trading, the Companies Act 13 prohibits the directors and key managerial personnel from the purchasing call and put option of the shares of the company. If such a person is reasonably expected to have access to the price sensitive information, it is in 1930 only. The strict rule for auditors is also followed in 2013, prohibits the auditor from performing a non-audit service to the company, where they are the auditor to ensure the independence and accountability of auditor is followed in 2013 only. Increase in number of shareholders is also followed in 2013. The maximum shareholders in private company is increased from 50 to 200. It is not in 1956. Enrichment in articles of association. The Companies Act 2013 provides enrichment. Apply the extra legal safeguards of the articles of association have been introduced. And it is also the electronic mode is also followed in 2013. Proposed the e-governance for various companies, proposing like a maintenance, inspection of documents in electronic form, option of keeping of books in tally and electronic mode. Financial statement is also in the websites, etc., etc. It is not in that in 1956. Indian resident as director. Every company shall have at least one director who has to stay in India for a total period of not less than 180 days in the previous calendar year. What I have set in the feature, it is only for the 2013, not in 1956. Independent directors, the Companies Act 2013 provides all the listed companies should have at least 1/3 of the board as an independent director, and other classes or classes of public companies may be prescribed by the central government shall be required to appoint the independent directors. No independent director shall hold office for more than 2 consecutive terms of 5 years, but it is not in 1956. And servicing notice of board meeting. The Companies Act 2013 requires at least 7 days notice to call a board meeting. The notice may be sent through electronic mode to every directors at his address registered with the companies, but it is not done in 1956. The duties of directors defined is also under the Companies Act 1956. The director had a fiduciary, legal or ethical relationship of trust, duties towards the company. However, the Companies Act 2013 has defined the duties of director. Liability on directors and officers. The Companies Act 2013 does not restrict an Indian company from indemnifying compensate for harm or loss it directors and officers like the companies in 1956. Thank you very much.